hear you. The Chief Justice and Justice of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw an eye to the attention. The court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Thank you all for being here this morning. This is our May administrative hearing. We have a number of items, and we look forward very much to hearing what you have to say about those items. We'd like to, in particular this morning, we'd like to welcome our newest colleague, Justice Curtis Wilder, who's joining us today. This is absolutely his first hearing, administrative or otherwise, and we know he'll contribute, as he always does, with great insight and judgment. So we will begin. The first case that we have is administrative file number 2015-11. This is a proposed amendment of MRE 404 and would require the prosecutor to provide reasonable notice of other acts evidence in writing or orally in open court. My understanding is we have two speakers, and the first one would be Mr. DeGroff of the State Appellate Defender's Office. And you have 3 minutes, as all of our speakers do today, and please use your time as wisely and as prudently as you can.
Thank you, Your Honor. Brett DeGroff from the State Appellate Defender Office. And I'm happy to, I have some remarks, but I'm happy to answer any of the court's questions at any time as well. SATO supports clarification of the form of notice of Rule 404B evidence, but strongly opposes allowing that notice to be oral. SATO encourages the court, as many other commenters have, to adopt a written notice requirement 15 days before trial. As we pointed out, and other commenters have pointed out, a written notice requirement and a period of something like 15 days would be consistent with other contexts, such as prior domestic violence evidence, evidence in certain CSC cases, alibi defense, insanity. Those all require written notice and anywhere from 10 to 30 days before trial. And I think it's worth pointing out, too, that those examples are the admission of those types of evidence are somewhat less complicated than 404B evidence. As the court knows, 404B analysis can be rather slippery. What is the evidence? What inference is it really being offered for? To give written notice and give everyone time to unpack that and get it right initially at the trial court stage, and then if not, make the best record possible for appellate review is better serves everyone, better serves defendants, prosecutors, the courts, saves judicial resources. So an oral notice would be difficult to review. As some commenters have pointed out, it's not clear exactly what that would mean. The proposal only says in open court, but the transcripts are not everything is recorded in open court. So would an offhand mention to defense counsel before transcription has begun, would that count? How could that possibly be reviewed? So there are a lot of questions, and we join with other commenters in recommending a written notice in a 15-day period.
Go ahead. No, you're all over 404B. You go.
Right, that's your favorite topic. What type of work would a criminal defense attorney need to do upon receipt of notice that the prosecutor intends to utilize 404B evidence? Is it just legal work to try to oppose that evidence or argue why it may not be relevant in the specific case, or would there be factual investigation that would need to occur as well?
There very well might be factual investigation. I've had a case recently where 404B evidence was offered of a lot of prior domestic violence incidents against a client, and defense counsel should, to give his client the best representation, would want to get ahead of that, find out exactly what those situations entailed, and then once defense counsel has those facts and finds out what this evidence is going to be, then there's also the legal aspect of what is the inference here, and is that actually permissible under 404B? I see my time has run out, but
are there any further questions? Okay, thank you very much.
Thank you very much, Your Honors.
Appreciate it. Our next witness will be Margaret Rabin, representing the criminal defense attorneys.
Good morning, Your Honors. My name is Margaret Rabin. I represent the criminal defense attorneys of Michigan, who are probably the subset of the bar who would be most affected by this proposed change. The question isn't whether notice is required. The question is whether oral notice is going to be sufficient, appropriate, and fair. I have a sign in my office that says, "Writing is nature's way of letting you know how sloppy your thinking is." And I think that that becomes particularly applicable in this situation where the proposal allows for a nonspecific and haphazard disclosure of evidence that's going to be used as a trial against a litigant generally, but primarily criminal defendants. Justice Viviano asked what happens if it's not a timely notice. There is both the factual investigation, did this really happen, what is the evidence to support this? And there is also the legal argument, because the prosecutor is required to state what aspect of 404B this evidence, in fact, is going toward, as opposed to simply propensity evidence, which is often the basis for seeking to admit it. That implies that there's going to be the possibility of investigation, research, counter-argument, and of course, for those of you who were trial judges, the 404, 403 inquiry to determine whether this evidence is admissible or not. An oral notice invites sloppy thinking, sloppy disclosure, and sloppy resolution. It puts the litigants and the judge in the position of trying to get a transcript of what might have been said if it's required to be on the record, of having to get the recording for the video courtrooms where there are no transcripts. It puts the judge in the position of perhaps being blindsided about, was there even proper 404B notice? All of this, oral notice always sounds real simple. In practice, I think it becomes a complicating factor in pretrial cases. And I will also tell you that a written notice can be very helpful in sitting down with the client and explaining why going to trial might not be the best solution in his case, if he knows exactly what the other evidence is going to be. I also CDEM is also in favor of the idea of imposing a deadline for this notice. The court rule speaks of reasonable notice. Reasonableness is in the eyes of the beholder, certainly. My time is
Yeah, would you please finish your thought, if you would?
Yes, and I think that the district court judge's proposal for a 15-day written notice requirement is workable. It will not interfere with trial schedules. It gives the defense attorney the appropriate time to follow up on it, and the rule still provides for the exceptional situation where the prosecutor finds out something outside of the notice period. Thank you.
Thank you very much, Ms. Rabin. Is there anyone else who would like to testify on that matter? Okay, let's move to item number 3, administrative file number 2015-18. These are proposed amendments of MCR 9.108 that would clarify that the Supreme Court has the authority to enjoin an attorney from practicing law. Our speaker on this will be Ms. Cynthia Bullington, Assistant Deputy at the Attorney Grievance Commission, on behalf of the Grievance Commission and the Grievance Administrator. Thank you.
Thank you, Justice Markman. Again, my name is Cynthia Bullington, appearing on behalf of the Grievance Administrator, who sends his regrets as being unable to appear here today in person. He is out of the country. The Commission does wish to voice its support for the proposed amendment. It is a situation where the Supreme Court is appropriately seeking to clarify its authority to enjoin an attorney from the active practice of law where there is the imminent potential for harm to the public from an attorney typically engaging in repeated acts of misappropriation, but it could be other situations as well. I note that the probate bar indicated that the phrase against should be placed in there, which is perhaps not a bad alteration. However, to make it consistent with other rules, perhaps the phrase of or from engaging in the practice of law would make it, again, more consistent with other rules in the disciplinary section. Any questions?
Thank you very much.
Thank you.
Let's move to item number 5, Administrative File number 2015-24, proposed amendments of MCR 2.116 and 2.119 that would allow for the filing of reply briefs in summary disposition proceedings. Our scheduled speaker is Karen Safran, representing the State Bar of Michigan.
Thank you, Justice Markman. Good morning, Your Honors, and Karen Safran. I'm here on behalf of the State Bar of Michigan. I'm the chairperson of the Civil Procedure and Courts Committee, which was the committee that originated this rule, so it's our fault that this matter is before you, Your Honors. The rule was proposed to achieve with two goals in mind. One is to have some uniformity in the practice for dispositive motions. We currently have a situation where some judges will issue scheduling orders that will allow reply briefs. Some judges allow reply briefs because the court rule doesn't expressly prohibit reply briefs. Some judges will not allow reply briefs because the current rule does not expressly allow reply briefs. And we also have situations in dispositive motions where parties will occasionally just say dump in a brief at the last minute, 2 days, 3 days, the night before the hearing, which really doesn't, it's just not fair either to the court or to the non-moving party. So the goal of the rule was to provide for uniformity in practice throughout the state, as well as to preserve the current system, which allows 7 days for the non-moving party and the trial court to prepare for the hearing. The proposed amendment shortens, achieves one of those goals because it achieves uniformity, but it doesn't meet the goal of giving the non-moving party and the trial court sufficient time to prepare for the hearing. Given the significance of a dispositive motion, which could result in the end of the case, shortening that time to 3 days is just not going to be enough time. I don't think it meets the interest of justice to require the non-moving party to scramble and the trial court to only have 3 days to prepare for a hearing and to prepare adequately for the hearing. I understand the court perhaps not wanting to extend the time because of the interest of moving cases forward, but in actual practice, changing from 21 days to 28 days really won't have a significant impact on the administration of justice. We have a situation, I practice principally in Macomb, Oakland, and Wayne County. In those counties, the judges quite often will limit the number of dispositive motions that they hear on any given call because of the time it takes to prepare and the time of the hearing. So there isn't currently a situation where you file your motion, you're not guaranteed a 21-day hearing in any event. And I think it better serves the parties and the courts to bump the time out a week, give everybody adequate time to prepare, and that would absolutely meet the goals of the rule and the uniformity. So that's our position. If there's any questions.
When you're talking about adequate time to prepare, you're already in a situation where you have the moving party's brief and you have the response to that brief. And now we're on reply, and the brief limited to 5 pages would be presumably very targeted at 1 or 2 issues raised in the response. And so I guess I'm wondering, I sat in the Macomb County dispositive motion call, very busy call, but I've always managed to find time to look at those briefs before taking the bench because they're very short and they're very targeted, and you've already done all of your other preparation before then. So doesn't that alleviate some of the concerns about the time frame, the fact that the brief is short and that it's targeted and that it comes at the end and it's of a lengthy briefing schedule?
It should be short. It should be targeted. That's what the rule is designed for, and that's why we tried to mirror it on the appellate rule. That isn't always the case. And
What is, it has to be limited, wasn't it limited to 5 pages in the proposed
the
rule?
proposal is limited at 5 pages, and it shouldn't be a situation, I know that was one of the concerns, that somebody would try to sandbag and raise new issues, and I think the trial courts would see through that. You still, though, you're losing that extra couple of days to prepare. It's how many days, how much time, what else is on the caseload, and just, I think 3 days versus 4 days is just a little fair for everyone, given the nature of the dispositive motion.
3 days versus 7 days, right? Isn't that the debate?
3 days versus 7 days, so it's a 4-day difference. The non-moving party is the party that's at the disadvantage, because the non-moving party is the one who receives the reply brief. So it's in fairness to the non-moving party to research, have the adequate time to research what may be raised in the reply brief and to prepare for the hearing. And also, if something is in the reply brief, to give the court and the court staff adequate time to prepare for the hearing. So we don't have a situation where the court's going to take it under advisement and not be in a position to issue a ruling at the time of the hearing.
Thank you very much, Ms. Saffron.
Thank you.
Next, we have item 9, administrative file number 2016-32. These are proposed amendments of a number of court rules that would require that all appeals from the probate court be heard in the Court of Appeals and would establish priority status for appeals in guardianship and mental health cases. Our first of 2 speakers is Sherilyn Robinson. Please proceed.
Thank you, Your Honors. I would like to thank you today for this opportunity to speak. I'm a citizen. Anyway, I support the proposed amendment that would require all appeals from probate court to be heard in the Court of Appeals. My family was recently victimized by the theft of our father's estate by one sister and again by the probate court. I believe that if this amendment were in place, the things that happened would not have happened, and it would improve opportunities for justice. I have transcripts and documentations to support my allegations that the probate court violated Michigan court rules and laws regarding disclosure of documents, rules of evidence. They threatened sanctions for us pursuing our rights. They appointed a personal representative to obstruct our access to documents and legal remedies for conversion and fraud. To summarize the 3 hearings, at the first hearing, our sister confessed to embezzling the funds belonging to the estate from the state of Michigan unclaimed property and using them to pay her bills. Knowing that a crime had been committed, the judge refused to sign petitions for the release of discovery documents and accepted the word of the alleged criminal that she paid half of the funeral bill, despite receipts and sworn affidavit from the funeral home to the contrary. At the second hearing, when our attorney said, "We believe a crime has been committed," the judge abruptly ended the hearing. He refused to sign the orders for discovery documents and threatened us with costs and sanctions for frivolous motion. At the third hearing, a request was made to remove the court-appointed representative for doing nothing. The judge temporarily appointed another sister as requested, but when she asked the judge to sign the order to release documents, he reappointed the first personal representative with explicit instructions for the sole purpose of remitting payments. Pursuant to statute, we were entitled to double damages for conversion of funds. The judge denied our request and recommended instead that we ask for costs for parking fees. Again, the judge threatened us for the defendant's costs and sanctions. Without the judge's assistance, we were able to obtain the documents which provided evidence of fraud and perjury in order to obtain the funds, and the life insurance policy that showed that our mother had possible ownership rights, even though she and my father were divorced, but her name was on the policy. The case concluded with no record of any crimes ever being committed on file, and all of the costs to collect the stolen funds were charged to the estate. I believe that had this policy been in place, that actually I don't believe that a lot of these things would have happened in the first place. So I'm not trying to increase the burden of the appellate court. I just think it would facilitate justice being done in the first place. I think not having any oversight that it was just allowed to happen.
Okay, well, thank you very much, Ms. Robinson, for sharing your thoughts.
Thank you.
Appreciate it. On the same matter, we have Marlene Tehan of the Probate and Estate Planning Section of the State Bar.
Good morning, Chief Justice, Justices. It's a privilege to be here today. I am the chair-elect of the Probate and Estate Planning Section of the State Bar of Michigan, and my comments are the comments and positions of the section and not the State Bar, and I've submitted a public policy statement to the court to that effect. And so today I'm here as the committee chair of the Probate Court Rules Committee, and we've been at work at this task since 2010. We originally came to this court asking for a rule change, and we were directed to the legislature. Laws have now been changed, and so now we're back to try to get the rules in place. I've had the privilege to work with the Supreme Court analyst Robin Eagleson on this in preparation of the ADM before us. And in response, the probate section chair submitted a letter, February 28th of 2017, commenting. And I'm here today to stand, representing to you that we stand firm on most all of that letter. But there's a few distinctions that I'd like to make. And so the few changes that we have to that letter are based on our reading of Chief Judge Talbot's letter of the Court of Appeals. So when I first read his letter, I was a little concerned because I thought our positions were very far apart. But then when I looked at his actual proposal, I realized that we're very close and our positions are very similar. So most of our changes are technical changes. There's one public policy change that we would suggest, and so I have 4 rules that I'd like to talk about. And one is 5.801. We do like his approach to maintain the structure and integrity of the rule as it was originally drafted and to have a simpler approach. So we like that. But there's one change that we would suggest, and that's in the paragraph in 5.801A2 that precedes the laundry list. Because the first item on the laundry list includes the word fiduciary, we think we need to add in the term guardianship under EPIC and the Mental Health Code. The second thing is for 7.202 and 7.203, we agree with Judge Talbot. No changes should be made to those sections. And I note in the ADM there are some changes. It's to 7.202, the definition of final judgment and final order. I strongly urge the court not to adopt sections VI and VII because what it has is partial laundry list in Chapter 7, and then we have a long laundry list in Chapter 5. And so my concern is these lists differ. And so if we have the right to have an appeal under some things in Chapter 7 and many things under Chapter 5, it'll be confusing and it could adversely affect the rights of the appellants. And then 7.210, the record on appeal. I would suggest a shorter version. It looks like Chief Judge Talbot is trying to add in the different types of things that equal proceedings in probate court. So I think it would be easier to just say in an appeal from a probate court proceeding, then the full record would not go up, but just the order appealed from. And then the full record would go up on civil actions. And finally, the public policy position. And this was in our letter, but the probate section feels so strongly about it, I just wanted to highlight it. We agree with what is in the ADM now, that the priority of calendar items would include guardianships under EPIC and the Mental Health Code. And, I'm sorry, it's just those 2 things. Guardianships under both. But there's one term that needs to be changed. The ADM references mental illness cases, and the term used in the Mental Health Code is involuntary mental health treatment. So I would suggest that we keep that consistent with the statute. And I'd be happy to answer any questions, and I will provide the text of my suggestions to Ms. Boomer.
That would be helpful if you would share that, and we'll certainly give it every bit of consideration we can.
Thank you very much.
Are there any questions? Thanks very much.
Thank you.
Thank you, Ms. Dean. Next, we have item number 11, administrative file number 2016-35, proposed addition of MCR. Oh, okay, I'm sorry. What is your name, ma'am? Sherry Daniels. Okay, would you please come up here? No, we don't have a lot of people coming from Alabama, so we certainly want to hear you. No, you understand you have 3 minutes.
Oh, yes. Oh, yeah. My name is...
Can you give us your name, please?
My name is Sherry Daniels.
Okay, thanks.
Please proceed.
I do believe that in the probate court, any appeals should go to the Court of Appeals. It's very important. I feel that some of their decisions are reckless at best, and that if the Court of Appeals heard these arguments, that the courts would be more appropriate in their rulings. The probate judges would be more thoughtful in their rulings. I have 3 examples. I was in a court, probate court. One family had a son that was born by another father, and there was a life insurance policy involved. They went to the probate court to find out how to resolve this issue. The judge leaned back, spewed some Ronald Reagan quotes, then told the family, "You haven't grieved long enough," and sent them home. Now, I'm not sure what the grieving period is, but things like this, these decisions, need to be sent to the Court of Appeals. If they were, these judges would make more relevant decisions. In the second case, an 84-year-old woman was deemed incompetent by 2 of her daughters. They quickly went through her money. Their son disagreed with this. He had her evaluated by 3 neurologists. They each found her competent. One even said to stop this nonsense. The probate court continued the nonsense. She was given a conservator and a guardian, which cost her even more money. The son, he was found in contempt of court. He was removed from the home, and he had to pay fees to the court. And a third argument was my case. We went to court regarding a life insurance policy of my father. One sister stole the policy. We had to go to court trying to figure out how to rectify this. The judge had extracurricular dealings with my sister and her attorney. I do understand that extracurricular activities is allowed if it's to advance the law. But if it's not, then those extrajudicial activities should not occur. The judge, we put in a motion to receive those paperwork she used to steal the money. The judge never marked dismissed, denied, granted, or granted in part. He never signed it. We requested the actual life insurance policy to look at all benefits, all beneficiaries, and any stipulations. Again, the judge never marked denied, dismissed, granted, or granted in part. He never signed it. As it turned out, I sent a complaint to Judicial Tenure Committee. They actually called me back. I was so happy. And then they asked, well, why don't you all get the insurance policy and look at the beneficiaries and the stipulations? Yeah, well, that's what we had asked for. But the judge did not, he did not rule on our motion. Judges, incumbent judges, rarely are challenged. And judges usually don't have a peer group to monitor each other's decisions. Therefore, we need these decisions to go to the Court of Appeals. Every appeal should go to the Court of Appeals, and these judges would make more relevant decisions rather than you haven't grieved long enough. They paid for an attorney. Now, if they have to go back, they have to pay a second time.
We know the distance you've come here today emphasizes the strength of your feelings, and we really appreciate you taking the time. And,
thank you very much.
Thank you for sharing your experience. Let's move now to item 11, administrative file number 2016-35. That would add provision MCR 6.008 that would eliminate the practice of circuit courts remanding to district courts except where otherwise provided by law. And our speaker is Tom Power of the 13th Circuit Court. Judge, we know you've come a long distance, maybe not quite as far as your predecessor speaker, but thank you for being here.
Well, thank you, Justice Markman and members of the Supreme Court, and I particularly want to congratulate my friend Justice Wilder. We came into the circuit courts at about the same time, and he's going to be an outstanding addition to your bench, and I'm very proud of him. I'm here to speak against this proposal. I represent or have a circuit with a colleague of 3 counties. We have a district court with 2 district court judges covering the same 3 counties. So we have developed over a period of 20 years and more a web of understandings and arrangements to handle our relationship that's worked quite well. One of them is to make use of the district court specialty courts. We particularly, the sobriety court, which is alcohol abuse, the domestic violence court, and the mental health court, and those have been especially useful. And the way it's done in our system is a felony case if the parties, which is plea bargain, prosecutor and defense lawyer, agree to an arrangement to remand to the district court to participate in one of these specialty courts, and if the specialty court, the district court, accepts it, then the district court will take a plea, either to a felony or a misdemeanor. And the understanding is if the defendant successfully completes the sobriety court, they won't go to jail, and the conviction will be reduced to something lesser. If it's a felony, it'll be reduced to a misdemeanor. If it's a misdemeanor, usually to something lesser. If they're unsuccessful, then they are sentenced on the plea that they made. If it's a felony, it's sent to circuit court, and we sentence them. If it's a misdemeanor, the district court sentences them and manages the probation. And this has worked quite well. It allows us to take advantage of the initiative and leadership our district court has shown in establishing these specialty courts. This will be forbidden under this proposal. Now, there may be a way around it. I've thought of a couple rule beaters already, dismissing the case and filing it again. There are other ways to do it, but there's no reason to outlaw this system. In general, what's wrong with having misdemeanors sentenced by the same court and felonies sentenced by the same court? For over 20 years, 24 years, we've been having district judges take felony pleas before bind over if the parties reach an agreement. And it comes to circuit court for sentencing. And our DOC probation officers handle it. That ensures some consistency in sentencing and probation management for the felony caseload. And if we resolve a case, or the parties do, in circuit court to a misdemeanor, it goes to district court, and they manage it with their probation officers, again, for consistency. I don't see what's wrong with that. I suspect this proposal is to solve local problems somewhere where district judges and circuit judges aren't getting along. But it's a statewide solution that creates problems for a lot of the rest of us. I suspect there are other courts have arrangements out there are going to have the same problem. They just aren't aware of what's about to happen. So I would urge you, first, reject it. If you do pass it, there is a provision in there that we can, for misdemeanors at least, use the district court probation system, and that would make a lot of sense. That would go a long way toward having some consistency in management, but I would eliminate the provision. It's got to be part of a concurrent jurisdiction plan. That's a whole nother discussion. But the probate circuit and district judges, 8 of us at that time, in our 3 counties unanimously voted not to do a concurrent jurisdiction plan. I could elaborate as to why that is, but that's not important. I would eliminate that restriction. If you're going to adopt the proposal, at least take that one provision out. Thank you for your time. I appreciate it. And okay.
Thank you very much for coming from Grand Traverse today. The last item we have is item 13, administrative file number 2016-40. Proposed amendments of MCR 2.625 and 3.101, and these would address recent amendments of MCL 600.4012 and clarify the authority and process for recovering post-judgment costs and provide clear procedures for garnishment proceedings. First speaker is Michael Nelson, representing the State Bar Consumer Law Section. Thank you for coming, Mr. Nelson.
Thank you. My name is Michael Nelson. I'm a member of the Council of the Consumer Section, and I'm also one of the attorneys for the plaintiffs in Verburg and the other cognate cases now pending in the Western District of Michigan, where the issue of garnishment costs is currently being litigated. Michigan current rules, particularly MCR 3.101R2, prohibit judgment creditors from taxing the costs for unsuccessful garnishments. At least that's the interpretation by the State Bar in its submission to this court, and it's also the reading by the federal court in the cognate cases. Despite that rule, creditors have routinely added the cost for unsuccessful garnishments to their judgments until 2013-14, when they were sued under the Fair Debt Collection Practices Act. The change proposed by these debt collectors would effectively allow them to return to the previous practice, which was not permitted by the court rules, and continue to tax the cost of unsuccessful garnishments. The amounts involved for most cases are minimal. We're talking in an average case maybe $20 to $80. But in the aggregate, they're substantial. Most of these cases are filed by large debt buyers. In fact, those who buy these debts at about 3 cents on the dollar and then file the majority of civil cases in Michigan's district courts. The cases that we have settled in the federal court, those debt buyers have either backed out or returned at least $9.2 billion. So in the aggregate, they're substantial, and I submit that this windfall would go almost entirely to a few large debt buyers who, as I said, paid pennies on the dollar for their debts. The proposal is written in such a way that, that it does not effectively make the creditors back out the cost of unsuccessful garnishments. And the reason is it would do that only if the creditor receives a negative garnishment return. And in fact, the majority of the garnishments are state tax returns, and the Department of Treasury does not issue garnishment disclosures when there is nothing to intercept. So in those cases, it would not apply. In closing, the Michigan courts have held in a number of cases that garnishment is a harsh remedy, and the rules governing garnishment should be construed to protect the debtors. I think there is no good policy reason to change that. The State Bar, in its submission, has divided the various proposals and supported those proposals which actually go to the change in the statute and oppose those that don't. And I would urge this court to follow the State Bar's position.
Thank you very much, Mr. Nelson. On the same file, we have Douglas Van Essen of the Michigan Creditors Bar Association.
Thank you, Chief Justice Markman, and thank you to the court on behalf of the Creditors Bar for, I think, the tacit admission that how and when post-judgment costs are taxed needs clarification and administrative attention by this court. I would like to focus on what we see as the flaw in the State Bar's proposal to the court. There's really two flaws. One is that unlike the pre-judgment process, which has a seminal defining moment, which is the entry of a judgment, there is no seminal event in the post-judgment process. In fact, hopefully the post-judgment process ends without any final intervention by the court or any opportunity to true up costs incurred during the process. If the court were to wait until the underlying judgment and interest are collected to true up these taxable costs, you would have a series of perpetual motions where there's another judgment following the original judgment, more post-judgment collection on the second true-up cost. We think that's inefficient and ineffective for not just the creditors, but also the debtors. These costs need to be, that are taxable, need to be collected as they are being incurred. The second flaw that we see in the State Bar's proposal is the concept of success while it may apply to garnishments, does not apply to the other taxable costs defined by the legislature in the post-judgment collection process. How, for example, do you define whether a debtor's exam is successful? Is it unsuccessful if the debtor doesn't show up pursuant to service? Is it unsuccessful if the debtor doesn't provide any useful information? The legislature has determined that there are taxable costs associated with those events, and we believe the system needs to allow the creditors' bar and the clerks who are issuing these writs and other post-judgment vehicles to assess these costs as they are being incurred. Is there adequate remedy for debtors who are being victimized in this process? Certainly there are. The supervising court is always available to sanction debtors who are not playing by the rules. There are, as Mr. Nelson has noted, federal and state statutes with onerous sanctions if the creditors are not sufficiently following what are truly taxable costs. There's also remedies under the state bar. We're all officers of the court, and if lawyers are engaging in a pattern of inappropriately proffering these costs, they should be disciplined. So we believe that the system that we've proposed would be efficient and would be fair to both the court system itself and also the debtors and the creditors, and that it allows these costs to be efficiently taxed as they're being incurred. I just want to make one final comment. We are not suggesting in any way, and our proposal does not allow or change the fact that an unsuccessful garnishment may not be collected. And so I disagree with Mr. Nelson on that fundamental point.
Thank you, Mr. Van Essen. Our next witness is Alyssa Gomez of the State Bar.
Good morning, Your Honors. Elisa Gomez speaking on behalf of the State Bar on this proposal. I'm honored to present comment on 2016-40. The Bar supports the proposal in part and does not support the proposal in other parts, obviously. I think that I'd like to focus on the portions that we've opposed and the effect that these proposals would have on the most vulnerable populations in the state of Michigan. We're talking about very unsophisticated consumers who may not have much familiarity with the court system. They limit access to justice for those unrepresented litigants, which is the vast majority of those debtors who are appearing in these types of creditor-debtor collections. The proposals as presented impose this new affirmative burden on debtors. It's a new process to object when the taxation of costs is imposed. The rule seems to indicate that, or the proposed rule seems to indicate that when the garnishment is issued, the creditor is allowed to tax costs regardless of the success or lack of success of the garnishment. And that if the garnishment is unsuccessful, it then is the sole burden of the creditor with no affirmative oversight or affirmative disclosure to subtract out those assessed costs. Again, this is a system that is deeply one-sided and affects the ability of debtors to understand how costs are accruing related to a judgment debt that they may have, and affects their ability to clearly object to them in any sort of meritorious way that the court could make sense of in such a motion. I want to address some of the comments that were made by the previous speakers. There's been comments that the supervising courts are always available, and I think that from the perspective of the State Bar, the question is, how available, truly? Is it available in any sort of straightforward process that is accessible to a debtor who may not understand very much about the paperwork that they've received? Is this proposal, in fact, adding more layers or more barriers to the process of objecting that tends to act to the detriment of the more unsophisticated party in these proceedings?
What are the barriers that are being added?
So the process specifically in 2.625K is that rather than just filing a motion, there's like a demand letter that is supposed to go from the debtor to the creditor with the sworn affidavit. And then if there's an accounting received that the debtor doesn't agree with, then there's a motion filed at that point, rather than just being able to straightforwardly file the motion.
When you say barrier, you mean added procedural steps?
That's correct. I mean, and I think that when we're talking about added procedural steps, the question is, what are they accomplishing? Are they accomplishing, additional access to justice for individuals? Are they accomplishing efficiency of the courts? Are they accomplishing justice, whatever that might mean in a particular situation? And so if procedural steps are being added that
Are you saying that these steps are cost prohibitive for people, so therefore there would be a barrier to people accessing the court system?
I'm saying that I don't think that most debtors, especially unrepresented individuals, are going to understand what they need to do in order to sufficiently follow the proposed court rule as laid out. I routinely represent very low-income people, and
so it's not a cost issue; it's a confusion issue.
It's a confusion issue. So I mean, when I speak of access to justice, I think that we talk about having a system of justice and a court system, especially at the trial, at the district and circuit trial levels, that is understandable and comprehensible, assuming an unrepresented litigant. I think that's how we have to consider much of this, because the vast majority of litigants across the state of Michigan are unrepresented.
So how fast should the court proceed?
I mean, I would recommend that the court adopts the comments made by the State Bar. There are portions of this proposal that do effectuate the legislative intent, the very explicit legislative intent, and it's outlined in our March 29th letter. And I don't think that the State Bar objects in any way to those adoptions. But the portions related to the taxation of cost, the new taxation of cost procedure, the limits on disclosures of information by garnishees, neither of those portions are supported by any legislative change that we were able to discover. And in fact, in many ways, they are proposals that are specifically in response, as Mr. Nelson spoke to, in response to lawsuits against creditor firms. So, I mean, I think that, the Supreme Court should proceed in a way that ensures access to justice. I mean, the bar is committed to trying to resolve some of these ambiguities, if there truly are ambiguities in how the taxation of cost is done in post-judgment garnishment proceedings.
And your views are reflected in the letters over the signature of Janet Welch, is that correct?
Yes.
Okay. Well, thank you very much for sharing.
Thank you.
Any further questions? Okay. Thank you, Ms. Gomez. Our next speaker is Jeff Kirkpatrick of the Court Officers and Deputy Sheriffs Association of Michigan.
Morning. My concern on this is more from a practical application of what happens with us and when post-judgment costs are assessed, and how I know that the comments thus far have been on garnishment, but there's many other remedies besides garnishment on post-judgment collections. One of those is seizure orders. And currently, the court's requested order to seize process in its own form, the MC-19, specifically delineates the post-judgment costs to date. So when we as a court officer, deputy sheriff, go out in the field to carry out that court's order, we are able to tell that defendant and collect from that defendant the funds that are due as of the date when we go out. My concern is if we do this as the State Bar is proposing, after any successful post-judgment collection, then we would go out on the original judgment. We would collect that. We would tell the defendant, you're going to get a bill for some amount of cost. When that bill comes, you need to pay it. If you don't pay it, then we're back out to collect that money again. Thus, there's another fee, there's another service fee, additional mileage, and to me it just seems like we're going around in a hamster wheel. So in my view, the ability for the defendant to know what those costs are an advantage. And for us as court officers, it's an advantage for us to know, because the defendant wants finality when we're out there dealing with this. And it's already, as I said on the form, it's the process, the way that it's handled currently. And I really don't think the issue needs to be changed. I believe the Michigan Creditors Bar proposal does provide the appropriate protections, for the consumers. Thank you.
Thank you very much. Are there any speakers that we have overlooked? Okay, well, this is our effort to open up the administrative process more directly to public comment. We appreciate all those who participated today. We will do our best to take your comments seriously into consideration, and we're pleased that we're now able to do that with the assistance and benefit of our new colleague, Justice Wilder. Thank you very much for being here. We stand adjourned.